Good afternoon, everyone, and welcome to the first annual Law and Religion Symposium. My name is Matt Latimer. I'm the current chair of the J. Reuben Clark Law Society, the Seattle chapter of the J. Reuben Clark Law Society. Some of you know what the society is because you're members of it. Others might not. But for those of you who don't know what the JRCLS is, it's a law society that consists of lawyers and law students, who are members of the Church of Jesus Christ of Latter-day Saints. There's about 270 chapters, student and lawyer chapters of Law Society around the world. And the purpose of each chapter and for the society itself can best be embodied by its mission statement, which reads, "We affirm the strength brought to the law by a lawyer's personal religious conviction, and we strive through public service and professional excellence to promote fairness and virtue founded upon the rule of law." So one recent initiative of the society has undertaken is to foster conversations and education surrounding the state of religious freedom throughout the world. It's a topic I think most of us will agree is increasingly finding its way into the forefront of conversations in the media, in the courtroom, of course, and throughout our society. And at its most fundamental level, religious freedom is the human right to think and act upon and express what one deeply believes in accordance to the dictates of his or her moral conscience. It's a foundational principle of the constitutional principle of the United States, and it's sometimes described as our first freedom, both because of its lead position in the current Bill of Rights of the United States, and also because our ability to act and upon our moral convictions is really a foundational principle upon all the other rights that we enjoy as U.S. citizens. But the limits of religious freedom are being tested and questioned as competing rights and interests vie for recognition. And I think this is complicated by the fact that people of faith don't always even agree among themselves what the definition of religious liberty should be, or how it should be exercised, or even how important it is. And others sometimes see it as something that is really just a pretext for discrimination or bigotry. So one of the challenges and the opportunities I think we have as living in a pluralistic society is that it requires us to have conversations with each other and with competing interests to understand one another and to negotiate space for each person to live out his or her life in accordance with their personal convictions while still respecting those around them. And I think we must constantly strive to protect these interests and balance these interests and seek accommodations for all interests within our society. It's my belief that those conversations are really important, but in order to have them successfully, they have to begin with a common foundation. So in this way, I think instead of dividing us, freedom of religion and conscience can create, as one writer put it, rejuvenating obligations. All recipients of religious freedom, every group and individual who is free to live according to the dictates of conscience, must in turn protect that same freedom for all others, especially the most vulnerable, whether they're religious or not. And that is the obligation, and it is rejuvenating because it enables diversity to be a source of national strength. So, on behalf of the Law Society, we hope this symposium will be helpful in promoting that understanding. Now, I need to first recognize some of our sponsors who you'll see listed on the screen behind me. First, with great thanks, we appreciate the support of the University of Washington School of Law and Stoll Reeves LLP, who are primary co-sponsors for this event. We're also grateful to the Church Council of the Greater Seattle, the American Jewish Committee, and the law firms of Romero Park, Carson Knoll, Johnson Graff, Kay, Moniz, and Wick, and Wilson Sonsini for their generous support of this symposium. It really couldn't have happened without those support. I also want to recognize the board of the Seattle chapter of the J. Reuben Clark Law Society and the organizing committee who spent a lot of time on this. I particularly want to recognize Jeff Burnham, Rob Critchfield, Wright Knoll, Jared Wigington, Miriam Norman, and Lisa Oman, who's really done a lot of work on putting this conference together. And particularly we want to recognize the University of Washington. When we approached former Dean Kelly Testy last fall about this, she was enthusiastic with her support and willingness to accommodate this kind of a symposium. She got us in touch with some really brilliant legal minds. I'm looking at the guys in the front row. And we appreciate her support, and also from our current Dean, Anita Krug. We appreciate Professors Clark Lombardi and Bob Gomulkiewicz. See, I did it. I got it right. Who have been really helpful throughout this process of thinking about topics and issues and working with our presenters and speakers to make sure that we have an outstanding program for you today. And finally, we need to thank the law school administration, particularly Kathy Klein and Maddie Bess, who many of you saw at the registration table. It's actually Maddie's birthday today, so she's giving up a bunch of her special time for us, and she's been really great in organizing all the logistics around this. And finally, I want to thank the speakers and presenters that you'll hear today. All of them have volunteered their time to be here. They, I think, as you can see from their biographies that you have, they're experts on these topics. They have a wealth of experience, and the fact that they're willing to come and do this, on a volunteer basis, really, I think, says something about their commitment to these issues and how important these issues are. So we thank them. Now, I want to just turn the time over for a couple minutes to Jared Wigington of the law firm of Stoll Reeves. Is Jared in here? Following Jared's short remarks, we'll be pleased to hear from Dean Anita Krug of the University of Washington School of Law. And then following Dean Krug's remarks, Brett Sharps, one of our presenters tonight, a professor at the J. Reuben Clark Law School in Provo, Utah, will introduce our keynote speaker. After that, we'll follow the agenda as outlined in your program packets. We will have some breaks. As you notice, there'll be some refreshments out in the hallway during those breaks. But we'll try pretty hard to stay on time and to make sure that we get out of here at the right time. For those of you who are lawyers, when you checked in, if you haven't signed up for your CLE credits, that information is out on the table, and so we invite you to come do that at the breaks. And if you, of course, you have any questions during the course of this conference, we hope that you'll find a member of the board who's wearing a tag like this, and we'll try to see if we can accommodate you. So, Jared?
Thanks, Matt. Welcome. I'm really excited to be here. It's good to see all of you here on this Friday afternoon. I was a little skeptical when I heard the registration numbers. Not usually a lot of turnout in my law school events on a Friday afternoon, but here we all are. It's excellent. My name is Jared Wigington. I'm an attorney at Stoll Reeves and a board member of the J. Reuben Clark Law Society. Stoll Reeves is sponsoring this event as a part of its commitment to diversity and inclusion, not only at the workplace, but also in our communities. Now, I'm of the personal opinion that contemporary notions of diversity often minimize, trivialize, and sometimes are hostile towards the notion of religious freedom having significant value. I'm grateful to be a part of a firm that is committed to the value of religious diversity. I am privileged to be associated with the J. Reuben Clark Law Society and to be here at this event with you. My hope is that we will all be edified and enlightened as our understanding of the Free Exercise Clause and other constitutional rights grows this afternoon. And I'm also hopeful that this conference will inspire us, those of us with personal religious conviction, to seek after greater understanding, to embrace our faiths, to exercise our constitutional rights, and for those who may not share those convictions who are in attendance, to also value those rights and respect them. Again, thank you so much for being here, and we're really proud to be a part of this conference.
Hi, everyone. I am Anita Krug, the interim dean here at the University of Washington School of Law. And on behalf of the School of Law, it is my great pleasure to welcome you here today for this symposium. We are so glad to see you here, and it promises to be a wonderful and fascinating day. We have long wanted to do a symposium on this really important topic, almost Every term over the past decade, the Supreme Court has heard important and controversial cases dealing with this subject, and as a result, the doctrine has been changing rapidly. In Washington State, we are seeing a growing number of cases that implicate questions of non-establishment, free exercise, and religious discrimination. It is a subject also that is increasingly important both internationally and nationally. We have students who are very interested in the subject and faculty who are experts on it. And I want to now echo Matt in thanking those who helped us put this together and the symposium and the CLE and make it possible. So we thank our co-sponsors who have been incredibly generous in helping us both to fund and to organize this event. These are Stoll Reeves and the J. Reuben Clark Society. And we want to extend thank you to a number of individuals. Our alumnus, Wright Noel, who first discussed this event with Dean Testy and reached out to our co-sponsors to get the ball rolling. We thank our alumnus, Matthew Latimer, who has worked tirelessly with us to organize and plan this symposium and CLE and to coordinate with the J. Reuben Clark Society. We also thank the speakers that will appear before you today who are willing to join us in Seattle and bring their expertise. We have today some of the leading scholars and litigators in the field, and we are so happy to have them here with us today. Additionally, echoing Matt, we thank Maddie Bess, who did enormous amounts to make sure that the details on our end came off very well, as well as Kathy Klein, who makes sure that this is a CLE eligible event, which is a very good thing. Finally, we thank the many faculty here who have been involved with this event and also contributed to making it possible. I wanted to note as well that after its completion, everything has finished for the day, we will be having a reception just down the long hall in room 115, which is the Perkins Coie room. And that, again, will be immediately following the symposium this afternoon. And so, again, welcome. I hope you have a wonderful day. And I will now turn it over to Brett Scharfs, who, again, is with the BYU School of Law.